conversations today, mainly probably Eagle Lab more than anybody else, but you know, do we get points for taking a minority district and making, or an influence district and making it into a minority? So if you had 8 with 5 minority districts, is that better than 4 minority districts and 3 influence? Is there any way that that's weighed, or is this just, or is 9 the actual number we got to have? None of this is pretty.
Right.
But like I said, a lot of these plans over here are in the same position, so you can make almost any of these work if you exported Ketchikan to, and I say Kodiak, but it could be the Prince Sound or whatever, to another district. It would be a.
You mean in Senate pairings?
Be a Senate pairing, and it would be a non-contiguous. You could say the water is making it contiguous, such as the Kodiak Metlakatla of the 90s.
But in the 90s plan there, I would suggest, Mr. Chairman, that you would need to justify that pairing based upon requirement of the Voting Rights Act and not upon the fact that it is contiguous. I would
well, but that's confusing too to me. Is it because if we, of course this is a requirement of the Voting Rights Act because we're pulling a minority district out of, or an influence district out where there's only 4 districts. So we had to do that. And so the reaction to moving the influence district out and pairing it somewhere else is that we're left with 3. And the reason we tied them together is because of trying to get that 9th seat.
But you're dealing with huge deviations.
But they're
oh yeah, we weren't trying too much.
They're within the statewide range. And the thing, you know, after playing with this for a very long time, and we've seen a lot of plans, none of the plans have had 9. They've either had, we've had one plan with 10, the rest have had 8. And the only way we think to get to 9, I mean, without really coming up with some unusual looking districts in the West, the only way to get to 9 is to pair that interior district with the southeast district. But like Chairman said, the impact of that is you're left with Ketchikan that would have to go with Kodiak or Cordova.
So whether they're actually contiguous or not there really doesn't matter, because if you have that pairing, then you have to pair somewhere else. Not contiguous.
What we're doing is drawing the plans so that the influence districts are contiguous. So that part meets all requirements. But what it does is leave a district that would be potentially non-contiguous in a Senate plan. So there's no other way. I mean, if you could create another influence district and pull that out, you'd still end up with the same position. You end up with 3 districts in Southeast, and you need 4.
And if you think about it, I mean, Kodiak has to be paired both with the rest of its House district and also with its Senate district by water. And we've seen plans that pair Cordova with Kodiak. And
so do you remember, wasn't that challenged in 90, the Metlakatla Kodiak? Did you say something about that the other day, or was I not? But see, I think that was because it was an influence district at that time, but I don't know. We're actually taking non-influence districts and making this pairing, but we're being forced to do it because of the Voting Rights Act. So I just don't know if that's a good enough reason to do it, or
if the Voting Rights Act requires you to ignore Alaska constitutional standards, then the board is justified in making that decision. The rub there is, are you required to do it?
But what constitutional standards are you ignoring?
Any.
contiguous.
You can ignore any of them other than state constitutional requirements. The Voting Rights Act trumps all of those. But the only thing that trumps the Voting Rights Act is equal protection.
But assuming that this is on the water, the borders would be played with. If Ketchikan were on the water, does it violate the Alaska Constitution to to pair it with another island?
If it was not required by the Voting Rights Act, you would get a contiguity challenge, and that one you may win, you may not. Our court has, in the past, they've paired ones that have been by that much water, but they've also said, we understand because of the way Alaska is geographically formed, that you have to use reasonable amounts of water at a time. So what's reasonable and what's not is anybody's guess. That's what 3 justices of the Alaska Supreme Court say. You can give some pretty examples. You couldn't pair Barrow and Ketchikan because they're both contiguous by water. The court would say no way.
What about Kodiak and Cordova?
I would say that probably is gonna, you know, I would say that's fairly reasonable, and the court would say, yeah, that's contiguous for purposes of Senate districts, yes.
But that would be.
Maybe even House.
That would be a House district, Kodiak for gold, I think.
Yes.
But, and then that district would be paired with Ketchikan, under the scenario we're talking about.
Well, you've got District 35 has as much water as District
Yeah, I mean,
36.
it could be challenged,
And
not
there's
contiguous,
12.
but I think that's probably, you have you know, I would feel comfortable defending that district based on contiguity. The court has upheld larger stretches of water before.
The other thing we tried to look at was keeping the western districts fairly similar to what they are now, you know, not having to break Northwest Arctic Borough from the North Slope Borough, keeping 39 pretty much the same, keeping 37 pretty much the same. The only real change for 38 is that it dips into a small portion of the Matsu Valley.
You gave up a lot of 38 to 37.
Yeah, 37 comes a little farther to the west.
20,000 people.
And so to get to 9, you can do so without having to mix this up too much, was one thing we looked at.